Live from San Diego, this is KUSI News.
The Lindsay Clancy murder trial resumes today. In Massachusetts, Clancy's mental health has been the key issue during the trial that has divided people online.
This is prosecutors believe she deliberately killed her 3 kids back in 2023. It's a difficult case to listen to the details for sure, but certainly has everyone talking. And with more on this murder trial, I'm joined by criminal defense attorney Vikas Bajaj. Good morning, Vic.
Good morning.
As mentioned, you know, it is so hard just as a mother and a human to listen to this case, but it has everyone talking and debating, believe it or not. But from a criminal defense standpoint, there is an important thing to note here that you've brought up, and that is the differences in state laws and why this case being played out in Massachusetts is so interesting. Can you explain?
Absolutely. In the United States of America, we have states that make their own statutes. So the legislators get together and they talk about the elements of the crime or the burdens of proof in a defense, like self-defense or any other affirmative defense. Another set of states uses what's called the Model Penal Code. And in the Model Penal Code, in a case like this that Ms. Clancy is facing, the prosecution has the burden of proof to prove beyond a reasonable doubt, a very high standard, that the mental disorder did not affect either the cognitive ability to know right from wrong, basically, or prevented the person from carrying out the act. The reason, Lauren, why this is so crucial in this case is if Ms. Clancy was charged in a different jurisdiction, California, Texas, New York, or a majority of other jurisdictions, the defense, would still have the burden of proof to prove to that jury that the mental disorder caused this crime or this action that's described as a crime. Would Ms. Clancy have a chance in any other jurisdiction? Very, very tough uphill battle. But in the Commonwealth, the law is so friendly to the defendant when mental disorders are taking place that it forces the prosecutor to prove a negative. Now, the prosecutor has to prove that the mental disorder, if it exists, and we can assume there is history of it, the prosecutor has to prove that it did not get in the way of her own volition or understanding the right and wrong. It's a very difficult nuance, different, but perhaps the results can and will be different if it were in any other state, Lauren.
Yeah, and you have medical experts on the stand disagreeing on that very topic as to whether, you know, this postpartum psychosis negates criminal responsibility, whether or not she was able to still know right from wrong. And there are things that they're pointing to, her sending the husband away so she could do this. They were talking about her attempted suicide. As a nurse, she knew better than to slit her wrist the wrong way. The temperature was wrong on her body for being outside for that. I mean, there's a number of these abnormalities. How do you think that plays into the jury's factoring of whether or not she's criminally liable for the killings of her 3 children?
Well, this is something law school never teaches you, and this is maybe 26 years ago for me now. Yeah. And if I were teaching a law school class, I would say the law matters because it gives the jury, the fact finder, ammunition to find the result that they would otherwise feel is correct. So much of this is whether they like the defendant, whether they like the expert witnesses. Now, you bring up an astute point, which is you have a battle of the experts. And this is a dangerous area for jurisprudence throughout the United States. Why is that? Because if you pay for an expert, they're supposed to give you an opinion on what's going on in a person's mind. Well, if another person, let's say the other side, a prosecution, pays that same expert, maybe there's a different conclusion. And whether that's righteous or wrong or a lie or the truth doesn't matter, Lauren. What matters is it is an example of the difficulty of reading what's inside someone's mind. And in criminal law, we not only need to have the act, but also the criminal state of mind. And this is the difficulty we see in these cases, self-defense cases, or any knowledge cases when experts are called upon to tell us what is in an accused's mind. It's a slippery slope, and there are benefits and there are deficits, surely.
Well, as this case wraps up, what do you think is likely to happen based on what you've seen play out? And either way, she is going to do some time, whether it's in a facility or a prison is really at question, right?
That's right. I mean, there are three outcomes. One is guilty of all charges, criminally guilty. One is not guilty, she did not cause the deaths. The other is not criminally responsible, which is the language in the Commonwealth. If she's not criminally responsible, but the act was committed, she will be then put into a mental health facility with periodic reviews. And realistically, in the Commonwealth, that means decades, at least a decade and a half before she can potentially be released if she's rehabilitated. An all-out acquittal, not guilty, I don't see that because she admitted to the crime, she did the crime. So the issue is whether she's criminally liable or whether she is not guilty because she's not criminally responsible. Mental health institution versus prison. So it's a serious decision.
Do you have an inkling either way where you think this could go?
Well, first of all, it's very clever to ask me this 2 times in different ways, but...
Well, when you don't answer my question, Vic, I ask my
A lawyer
job.
not answering a question correctly, Lauren?
Shocker, right?
Well, I will tell you this. You know, I've learned long ago not to make the predictions, but I will tell you, once you're in the court, the jury listens to that evidence. They've been astute and attentive in this case. Yeah. It's a difficult case, but it would almost be foolish for me to pontificate on the result without actually listening to and observing every piece of evidence.
Yeah, well, it certainly is just such a disturbing case, but one that has really raised a lot of questions. And do you think that it could be possible Massachusetts changes that aspect of their law when it comes to mental health?
I would say so. It depends on the verdict in this case. There's obviously a big lens on mental health postpartum after birth. But I think the Model Penal Code has a unique shifting of the burden. That shifting of the burden may in fact benefit the defense, which is what constitutional law looks at. It doesn't hamper the defense. I believe it will be revisited in the next, let's say, within 5 years after this case reaches appeal.
All right. Vikas Bajaj, always appreciate your expertise in this matter. Thank you.
Thank you.